Hey, and welcome to Making Law Simple. My name is David Helm, a licensed practicing attorney in the state of Michigan, and I will take your sloppy thirds. Thank you very much for being here, KJ. Welcome. And everyone else, we got Stray in the chat, Mads in the chat. I'm a pensioner now. I am a pensioner now. This is like my when you retire and then you get the job at the golf course, this is the golf course for me. But welcome, glad you're all here. Hopefully you guys can hear me okay. Again, this is still like not the normal setup, so I got this little mic sitting sort of down here. I'm going to adjust it though, because I feel like I'm not talking into it. A rare MLS stream. Yes. All right. So today was day one of James Crumbley manslaughter trial. If you've been following me for a bit, you know that I covered all of Jennifer Crumbley's case, as well as Ethan's case, the preliminary examinations for all of these cases. And I am still of the same opinion that it was impossible for James and Jennifer to know what their child was likely to do. But this is going to be more of a compare and contrast between Jennifer Crumbley and James Crumbley trial. Oh, and Lady Law, I forget her last part of her name. Anyway, she had some questions for me about electronic discovery. So if you are in the chat, let me know what your question is. But let's talk about what we heard today. We had opening statements from both sides. The state obviously goes first. The state's opening statement was very, very, very similar to what they presented in Jennifer's, except it was I don't know. It was a little different. I think it was a little, they got the practice out of the way with Jennifer, right? And so it was a little more polished, I guess is a good term. So I want to know what happened at the end. We're going to get to the end, Josie. We're going to get to the end. I'm going in order here. So essentially, what the state is arguing is that James and Jennifer Crumbley created a dangerous situation by supplying Ethan with a firearm, knowing that he had some sort of mental health issue that then put society at large in danger. It's a very unusual theory. It's the first that's being tried the second. This is now the second trial. But it's this, second time that it's being tried anywhere in the country. So that's essentially the elements of the case. Now, the defense, with their opening statement, made a good point by saying, and my notes for the opening statement are all kinds of weird. Oh no, here they are. The defense for their opening statement made a good point in saying this case is about what happened outside of the high school, not what happened inside of the high school. And so you're going to be showing a lot of videos and hear testimony about what happened inside of the high school, but that really doesn't matter for the purposes of this trial, which I agree with. And I thought that was a good way to frame the issue for the jury. Don't worry about all these things that we stipulate to, all these bad things that we know Ethan did. Worry about what happened outside of the high school, and let's just focus on that. Don't let this was a tragic event, so we're going to convict just for that sort of thing. So I like the way they framed that. We had some pretrial issues that were addressed, evidentiary issues. You missed the corrects. Correct. Yeah, there wasn't a lot of corrects today. So one of the pretrial issues were text messages between Ethan and Jennifer. The state wanted to admit those, and those were the judge ruled that those were not admissible. That's out of court testimony. Hearsay exception doesn't apply. And so none of the text messages between Ethan and Jennifer are coming in. We saw a lot of those text messages. Well, maybe not a lot, but we saw some come in. The group text messages, however, those will come in. Those are the ones involving James, Jennifer, and Ethan. So things like what is it? The not the I'm hearing things or I'm seeing things text, but the other ones regarding getting your him getting his homework done, him having a fit, and things like that. There were some text messages that came in where there were group texts. There was also text between Ethan and his friend about wanting to do something really bad that was sent at 2:30 a.m. on November 21st, so the morning of the shooting. That was offered by the state, and that was not admissible either. There were Facebook messages that were not admitted. I didn't get the context of those. There were other text conversations, such as Ethan, don't do it, that Jen sent to Ethan, and the judge said that she was taking that under deferment. We'll address that a little bit because I don't remember her ruling. And then there were two different photos that were deemed inadmissible. And again, we don't know what those photos are. What about the message to Andy from Jennifer? I thought that was ridiculous that they let that in. Yes. They're allowing a lot of hearsay in. The judge did make a ruling that let me go down to it here. So the text messages between Jen and her friend is excluded, but can be introduced for the purposes of impeachment, and the judge would be open to reconsidering it. Now that's interesting because I think that ties into another evidentiary issue that happened towards the end of the case. There was a hearing regarding uh, the defendant from jail communicating with somebody. Everyone was sort of like coy. Josie, this is what was going on. Everyone was coy as to what was going on, what exactly happened. They didn't want it out in the public. I went through the docket. I didn't see a motion about this that was publicly available. But it seems like James was communicating with somebody from jail, and those phone calls are recorded. I'm not sure exactly what the objection was, if the state wanted to exclude or wanted to introduce those recordings for some reason, or just wanted him to stop. But there was a motion to prevent James from contacting anyone other than clergy and his attorney. And so that was resolved by way of an agreement that that James could communicate from jail with his attorney, and he could also do research to assist in his defense, but he wasn't allowed to communicate with anybody, and that would remain in place until the jury returned a verdict. The only reason why I make that connection is because they were very coy about it, and the judge said that Exhibit 133, which was the text messages between Jen and her friend, were to be excluded unless they were appropriate for impeachment purposes. And so I don't know why you would have text messages between two people that aren't going to testify, presumably, uh, be available for impeachment purposes. So that's my takeaway from that. But that's essentially that was what was going on at the end of the trial. I wish there were more technical people involved. Something being cached, something being cached. Just means it is on the phone. It has nothing to do with if it was viewed. Yeah, I heard that testimony as well. I heard that, but he is qualified as an expert, so he's allowed to testify wrongly. I don't think the photographs that they were talking about were the firearms or the target. The target. They both had the same image of the target. Nobody's disputing that. Yes, it's probably technically wrong, but no one's disputing that they went target shooting and took pictures of the target. Let's see. Why would the state expect them to have read his phone at that time? That's excessive. Well, the state is operating under the theory that if it's on the child's phone or on anybody's phone, then everyone has access to it, I guess. I don't really get it either. The shooting victim was ridiculous. Yeah, okay, so let's go back. So the first witness was the same first witness as the Jennifer Crumley's trial, and that was Molly Darnell, who was a teacher at Oxford. She testified. I said this was going to be a lot of cut and paste, and it really was. She testified to the layout of the school, that she was sitting in class. All of a sudden, she heard a commotion. Kids were running. It sounded weird. She heard some pops Saw a bunch of kids running out the door. At first, she thought it was lockers closing, and then she closed. She saw somebody dressed in black with glasses on. Never seen the kid before. The door was locked. She was shot. A lot of the same things. So then we go on to, and there's no cross for that. There was no cross in Jennifer's case. There's no need to cross this witness for the defense in this case either. Then we go on to witness number 2, who is Edward Wagarowski. I don't know how you say his name, Oakland County Sheriff. He was the 5th witness in Jennifer's trial, but he was the first in, he was the second in this trial. Now he testified essentially to the same thing, that he's a forensics expert, a technical expert, and can extract all this information. And it's through this witness that a lot of the text messages and videos and things like that are admitted. What's interesting? Yeah, let me pull this up. Let me see. Are there any questions in the chat? Let's see if I missed you. Let's see. Did you hear them say something about articles coming out? Yeah, but I don't know what that was. I didn't see an article come out, and I'm not sure exactly what they were referring to, because I looked for the motion and I didn't see a motion. And we have a stipulated order, which everyone's going to see. And we know what the stipulated order is that he's not allowed to communicate with anybody, but he can research and communicate with his attorney. So I don't know what exactly they'd be talking about. But it was there was a gag order in place in this case. No one was allowed to talk about it. So, and they're still not allowed to talk about it. In fact, the gag order in Jennifer's case is still in place until after James's case is done. So they're not even allowed to talk about it. And it sounds like they're alleging that James violated the order somehow by communicating with somebody about something. Oh, we're going to talk about this. All right. So here, this is the minivan cop.
Do their job. And then probably a few minutes after that, our captain came in and said that there was a shooting at Oxford High School, and the phrase he used was all hands on deck.
Okay. So what'd you do?
Being what is referred to in the business as a computer nerd, you just grab your stuff, your computer, your laptop, what you think you might need, what we had no idea what we were getting into. And I knew Oxford was a long ways away from the Pontiac area. I figured by the time I got there, it was going to be long over, and me and my partners are just going to do what we do.
Okay. So did you get a squad car? Did you get an unmarked car?
I have an unmarked, at the time I had an unmarked white minivan with emergency lights and siren in it.
So did you start heading north then?
Yes, sir.
All right, tell me about that.
Well, at first it didn't seem real. I remember pulling out of the parking lot, and I looked to my left, and there was some patrol cars coming around the corner. There's the medical examiner's office down there.
Oh, wait, I'm sorry. That was from Jennifer's trial. Let's actually take a look at James's trial testimony.
And so with the lead car, I've always been told the lead car in a situation like that, you always hold that intersection for everybody else behind you because they're coming. And so as I entered into the intersection, I stopped dead in the intersection with the lights and siren going. And I counted at least 16 vehicles just go screaming past me. And we start getting into town, and northbound traffic's blocked.
Oh, he's crying again.
I remember going against oncoming traffic, and now you see cars coming at you, and you're the whole way there. All I could hear on the radio was.
I'm just doing this to point out that in both, he's wearing the exact same outfit. He is completely fine testifying. And then all of a sudden, he gets emotional at the exact same time. So that's all I wanted to point out with this fucking guy. Because everyone was talking about how emotional he was during Jennifer's trial. The exact same thing. Does he have a trigger word for tears? It's like, tell us how you got to the school. And then he goes on about young teenagers in skimpy little outfits and things like that, which I find highly inappropriate. But what it reminded me of is, if you didn't know, I was in a movie once. If you check out the movie 61, it's about Roger Maris and Mickey Mantle competing to beat Babe Ruth's home run hit. Anyways, it was filmed in Detroit, and I was an extra, and then I was a featured extra. But it reminds me a lot of that, when they're like, okay, next time do it with more tears, and it's like one after the other, the exact same thing. And that's what we have here.
And I'm like, then it like really came real.
Staging area
Like,
on Ray
know
Road,
what, as a state
Meyer.
police.
That's what I kept on hearing. There's so much radio traffic. I heard bits and pieces of other things, but that like really stuck in my head. And so we're just driving north, and finally, I just see a Meyer, and I'm like, okay, well, we got to be far enough north. This is where I got to go. And so I pull off onto Ray Road, and I meet up with other deputies in the area.
If you could describe to us what you saw when you arrived at that Meyer.
That was tough. That was really tough.
Yeah, the crying on cue. That's kind of what I was getting at. The crying on cue. It's extremely obvious if you watched both trials. That at the exact same time he starts crying on cue. He's talking about the kids he saw in their outfits and everything is it's like he's rehearsed this. Unfortunately, the jury's not going to see that, because presumably the jury, if voir dire was proper, didn't watch Jennifer's trial. So they're not going to see this. They're going to see, or they're not going to see the comparisons. Meyer makes him cry. Yeah. The thought of going to Meyer makes me cry too. If you guys have ever been to one, they have 10,000 registers, and only one with the slowest employee operating it is open at any given time. So, yeah, what you figure too, by the time like the fourth or fifth or sixth time you say it, the emotions are kind of out of you. Right? He's testified on the stand. He testified that he's been qualified as an expert at least 13 times, which means he's testified a hell of a lot more than that. And he's already told the story once in this exact courtroom to a jury involving this exact case. And like someone said earlier, he's probably told it 100 times already as well. And just to get emotional at the same point was it's almost laughable if it wasn't so tragic with the way they're trying to prosecute these parents. Let's see. Okay, so Lady Law. Are you going to play the video again? What video? Oh, I had Lady. Well, let me know what video. I got Lady Law's question here. All right. Making law simple. When discussing evidence and considering your educational focus on streams, can you explain the phases of e-discovery within the case's evidence presentation? It sounds like a sounds like a classroom discussion. I'm not sure exactly what you mean by within this case's evidence presentation. And considering your educational focus on streams, could you explain the phases of e-discovery within this case's evidence presentation? Okay, so I'm not sure exactly what you're asking me, but I can talk in general terms. We deal with a lot of e-discovery, electronic data, right? And he was somewhat right in talking about metadata and things like that. So metadata basically is data behind the scenes that you don't necessarily see. You have an image, That image is made up of ones and zeros. We know that, and it tells us, what color and things like that. But behind that is a lot of other data that tells you how it was created, uh, when it was created, where it was created. There's a lot of other things behind it like that. And when you get a Cellbrite is a company, it's just one of a dozen companies that do these data extractions, and they'll show you essentially when you get the report, they'll show you a thumbnail of the image. You also have the image, but it'll give you all that metadata information so you can track the GPS locations, where it was created, what device it was created on, serial number for the device that it was created on, all kinds of things. There's also other stuff too. Like anytime you print stuff, uh, any modern printer, any printer made since like the 80s or the 90s, really, there's actually a little bit of yellow code in this printed and the white. You can't see it, but it's printed on there, and it actually gives the serial number and a bunch of other stuff for the printer that actually printed this. So you can't escape this sort of data stuff. So it's given to you in that way, but obviously you're not going to necessarily present it in that way because it's fairly technical. They did show some of the screens to kind of give you an idea of how it looks. They showed the Cellbrite with the thumbnail and then all the data and things like that, where they got the information from, uh, and that sort of thing. But it takes somebody with knowledge to be able to testify to it. Not just anyone should be able to. I'll give you one example. I had a client, and she was up for parole violation because the state had alleged that she had taken vacation out of state and didn't ask permission for it. Well, the state went on to Facebook page and saw a photograph of her with her family, like on a beach in Florida or something. And she said that no, that was an older photo that she just uploaded fairly recently. That it wasn't actually like taken in February of whatever year it was. The state didn't have anyone that actually could testify to the metadata. So they weren't able to dive in. We could see the metadata, we could take a look at it, but nobody was able to be qualified as an expert to testify to it. So it ended up being inadmissible. I'm not sure what else, you want to know about that, about presenting it. I mean, all trials are performances, right? So you don't want to put up a bunch of data points. You want to put up an image, then have your witness testify as to what uh, data was eventually extracted from that image. I don't know what else exactly you're asking me, and I'm way behind in chat. So if you're asking me another question, go ahead and put some like red question marks around it, and I'll try to find it. Let's see. I haven't seen a 3-mile lane manned by humans in over 10 years. I know they got the self-checkout thing coming in now, but that was always a thing when I was growing up. And in the 80s and the 90s, whenever you went in there, they had 10,000 lanes and nobody was working. When they were describing the video of Ethan shooting people, kind of had a hard time listening to it. So sad. And it is. It is sad, and it's a tragic event. And I think it's important for people to be able to somehow separate themselves from it. I'm a cold-hearted attorney, so I can easily separate myself from it, but a lot of people can't, and that's one of the bigger issues when you're dealing with a jury. And so I think the defense did the right thing by putting out there ahead of time. Listen, it's not about what happened in the school; it's about what happened outside. The video of the shooting. You're talking about the video of the shooting? What about the video of the shooting? Oh my God, I'm so behind. Okay. Lady Law, I know you've been following it. I'm going to try to just focus on yours for a second because I know you have class in a bit. Oh, you're taking notes. Just have your class jump in here. Let's see. He's talking like John Candy in Planes, Trains, and Automobiles. The cop, not Dave. This guy. I don't like this guy. Look at him. Look up to the sky. He's holding back his tears. He's holding them back. So they don't fall out. He's got to tip his head back. Yeah, I was going to get to if your computer or if your printer, it's like a lot of like this printer is Wi-Fi and stuff like that. It'll say like the Wi-Fi router that's connected to and all kinds of stuff. They will find you. So there's your free piece of like conspiracy stuff. If you're gonna, there's something to be said about sending letters with cut out pieces of magazines, right? Let's see. Reptile strip. Yeah. No, I'm the homeless internet lawyer. It is hard when the victims are kids. But see, and this is the thing. Like under is it 403? I don't remember if it's Michigan Rules of Evidence 403 or not. With the more prejudicial over probative, they're not playing. Did they play the video? I can't remember now. Did they play the video or did they just talk about it? I mean, I feel like talking about it was almost. Nah, it's probably not worse. It's probably better talking about it. I mean, the state does have the burden to prove that a death occurred, and they don't have to stipulate. So they're up to, they can do it. Although it seems like, I don't know if they played the actual video or not. I know they played a lot of surveillance video, but I don't know if they played the actual video of the shooting just yet, anyways. Although this guy's done. So I should get us back on track a little bit. The second witness, this guy, he's done testifying today, and cross-examination hasn't started yet. So my question is, how can we have the jury understand e-discovery or discovery in all? It's not about so much the jury understanding it. It's about the presentation to the jury. So, for example, say you just have a photograph. I don't have a photograph. But say you have a photograph and you want the jury to see the photograph. You have to go through the foundational steps to establish that it is what it purports to be. Now, the person who took the photograph doesn't have to be the one that establishes it. So long as they say, yeah, I was there at the time and that's what it looked like. And that's a fair representation of the scene at the time I took this photo, or at the time that this photo is depicting, right? Now, you don't need to go through the whole steps as to necessarily who took the photograph. You just have to say, here, I'm showing you this is a photo. Yes, does that look like your storefront on such and such a date after, the windows were smashed in or whatever? Yep, that's how it looked. Okay, cool. And then you admit it, and now the jury can see it. It's the same thing with e-discovery. It doesn't matter who necessarily took it, or in order for the jury to get the idea that that photograph represents the front of the store after the windows are smashed in. So with the video, we have potentially chain of custody issues. Is it what it purports to be? Who downloaded it? Who saved it? And that sort of thing. But if there's no chain of custody issues, that's all pretrial stuff that you would potentially attack. But once you get through the pretrial challenges to it, then it's just admissible. This particular case, this witness here, he testified that he put a series of videos together and edited them. Presumably, the entire videos in the raw form would have been presented to the defense, And rather than making the prosecutor play each individual video and then play the certain parts that they wanted to, and then go to the next video and then play the certain parts, they stipulated to allowing it to be edited together and presented in that way. If the other party stipulates, then there's no issue. Obviously, there's no evidentiary issue to it. There could be a number of reasons, strategies why you would do that. Most notably would be time, right? Let's just get through this, these surveillance videos and all this stuff, because we don't want to focus on that. We want to focus what happened outside of the school. And so there was video of the shooting because he edited everything together. But that's why you would do it. But if there was an evidentiary issue, if there was a chain of custody issue, if there was, the metadata is not matching up, well, you're saying this, but the data saying that, that's really for a pretrial hearing to work out those details. Let's see. So at the end, they mentioned 8.119, and I tried to Google it, like I was a lawyer, but I am not, and I don't get it. Does that mean James and his lawyer were worried about personal info getting out? Let's see. So I'm not sure exactly what they're referring to either, but let's pull it up. Let's see here. 8.119 is what is going on? No. Was it 8.19? It's not a rule of evidence. Let's see here. Let's see. 8.119. 8.119 is a duty of the clerk of records. I don't get this. To records in every trial for purposes of this rule, records are to be identified. Review record statements, filing of documents and other materials. The clerk of the court shall proceed. Oh, I know what they're talking about. So they're talking about is having a confidential, off the record, in camera hearing, removing things from the public. That's what they're talking about. So what the judge was saying is that, this is a highly sensitive topic. We don't necessarily want it out in front of the media. But I don't have grounds to make this a closed door hearing. So a lot of times you could do a closed door hearing. The most of the time that it happens is when you say you have a child that was SA'd, right? And the child's going to take the stand and testify. The jury will be there, the attorneys, the defendant, the judge will be there, and that'll be it. And the rest of everyone else in the courtroom will be forced to exit, and they will conduct the hearing in secret. That actually happened in Jennifer's trial too. There was a closed hearing in Jennifer's trial. At one point, it was during the jury voir dire. Actually, there was a motion that the court was going to hear during jury voir dire, and we were all forced to leave. And that was just before lunch, so the jury, everyone was forced out, and then they had their hearing in secret. Obviously, the defense is allowed to be there, and the prosecution, and there is a record actually made that's available for appellate purposes and things like that, but it's not made available to the public. So that 8.119 is regarding the clerk of the court sealing certain documents, and that's probably why this motion wasn't available when I looked. It was probably filed under seal, which means that it's filed for the court's purposes, but no one else can see it. I have no idea what kind of sensitive information was in there. That's kind of the purpose of 8.119. Let's see. Was the defense objecting before the first witness was about to claim Ethan had a trained shooter stance? As big as I think it was. Let's see. Was the defense objecting before the first witness about the... I don't remember. I'm sorry, I don't remember. All I remember I wrote down after closing arguments was short and sweet. And I think then I probably drifted off and did some work or something, because then the next thing I know, there was the witness on the stand. Let's see. Floppy disk can be tracked. Good to know. Let's see. Yeah, right. Get a typewriter. So, like, someone does not understand e-discovery. How can you present that to the jury? All right. So, if the oh, I see what you're saying. So, like, this guy's getting his e-discovery stuff wrong. Like when he's talking about what cached images are on a phone, and that means that somebody viewed them and saved them. So let's say we're going to assume like our position is that is a wrong, technically wrong um, statement to make. You have the battle of the experts. That's really what it comes down to. You need another expert on the other side to say, I reviewed the notes, the reports from this expert, this guy who's holding back his tears, and I reviewed his testimony, because experts are allowed to view other experts or other testimony. They could sit in the courtroom the whole time because it's part of their analysis. So they can then testify and say, no, when he said that because they were stored in a cache, that means that they were viewed by the same person or saved by the same, or whatever he said, that was wrong. He was absolutely wrong about that, and here's why. That's what you do if like this witness doesn't actually understand e-discovery. And you say e-discovery. Discovery is discovery. Discovery is the opportunity for the parties to share information. That's all it is. It can be done through subpoenas. It can be done through court orders. It can be done through court rules, such as in most criminal cases, the court will say that if you're going to admit evidence, especially in a criminal trial, you have to present it within 14 days before trial. Obviously, this case is they've been exchanging evidence for a while, but you have to present it in a reasonable amount of time so that the other side gets an opportunity to examine it. So that's just all that discovery is. It doesn't matter. It could be a photograph, a piece of paper, digital information, whatever. So that's all discovery is. E-discovery is simply digital information being shared. It's the only difference. It's just digital information. So unlike this piece of paper that I can pull up and say, here, this is it, and I'm purporting it to be, written by so-and-so and signed by these parties. This is a contract. It's just a digital version of it. And if people want to challenge it, okay, here's a good example. I had a client, not a client, son of or I represented the son whose father amended his trust digitally in Adobe. So he actually went in and he like redlined things out and typed over top of it and made all these notes in Adobe, right? Well, how do I prove that he actually did it? Well, you could download the original file from his computer and see that it was created on this particular date, on this particular device that has this particular serial number, and at this particular location hooked up to this particular Wi-Fi router, and show that more likely than not it was probably him sitting on his laptop doing this. So that is that's essentially how you would handle e-discovery, and how I would explain it to somebody is that it's simply just like any other document. It's just in digital form, and it comes with all these tags and tails. And actually, it's more reliable to some extent because it has all this other information in it. So when you're pulling down cell phone data, it's a lot easier to say, well, that text message was sent from that particular cell phone, which registers to this number, and then sent to this other cell phone that registers to this other number, than it is to say, see that scrap of paper with that note written on it? That was actually sent, from the defendant to the shooter or something like that. Oh, really? Do you know? Compare the cell phone data with the communications and these 200,000 text messages with Ethan's journal. You know when the text message was sent. You know if it was read. What you don't know about the journal is when it was written. The only date in Ethan's journal was I think it was 2 days before the shooting. And so when he wrote it, I have no idea. He could have written it a year before and put the date in there 2 days before. Or he could have put the date in there 2 years ago, anticipating that was going to be the date, and he was off by 2 days. We don't know, but you know more with the e-discovery. So it's actually more reliable for a lot of things. See, I don't know. I don't know if they actually played it or not. I am way behind in chat. Sorry, guys. Oh, let's see here. Well, in theory, all evidence should be prejudicial. Otherwise, there's no case. Uh, the question is it more prejudicial than it is probative, such as showing photographs of a child's autopsy? It's probably more prejudicial than it is probative, because what you're trying to prove is that somebody's dead and that they died of gunshot, right? Or there's a bunch of different ways that you can do that without showing photographs of dead kids. Why do I hate chat so much? I'm trying to help you all and answer your questions, Murphs. Okay. So I'm going to take a pause on the chat. I left it where it's at. And I just want to talk about this second witness a little bit more. He literally testified to absolutely everything. No, I don't want to say that. Not literally. He testified 95% the same way as he did in Jennifer's testimony. There are a few differences. Let's see. He testified regarding the text messages between James and Jennifer, where James said Ethan looked like he had way too much to drink that night or last night. Net seeming to apply that he did drink, although I didn't get the implication from just reading it, but I think that's what they're implying. There was the video of Ethan playing with the gun, 2 videos actually that were sent to Ethan's friend. They were James was home during the first one, but apparently his GPS location says that he wasn't home. And in fact, he was door dashing during the second one. The new stuff that came up was text messages between James and the father of Ethan's friend. If you recall, one of the issues with, potentially the red flags that the state is saying that the parents should have had is that Ethan's friend left suddenly and abruptly just before Halloween. Apparently, James had text message conversations with this friend's father, and Ethan was trying to get in touch with his friend. It sounds like, at least in these text communications between the fathers, and his friend wasn't responding. The friend's father texted James back and said, yeah, he wasn't doing too well. We sent him to Wisconsin for OCD treatment. He'll be gone for 60 to 90 days. There are follow-up communications about maybe once he gets settled into the place, then Ethan and him can talk. Ethan and his friend can talk and things like that. But he was probably embarrassed and didn't want to tell anybody about it. That's why it seems so abrupt. And also, please don't tell anyone, even Ethan, I guess. And that makes sense as to why the school was saying Ethan's friend left suddenly. And like nobody kind of knew really what happened. Or they kind of knew, but they weren't supposed to talk about it. Because it was almost word for word what Ethan's friend's dad texted James that the school was also reporting. So that was the new thing that was added with this particular witness in this particular case. All right. Hocus pocus out of focus. Yes, I will be putting my notes in Discord, although I don't have a ton of notes because it's literally copied from most of the notes. I just copied from Jennifer's trial and drug over, except instead of it being witness 5, it's witness 2. Let's see. Does chain of custody go to admissibility or does it go to the weight of the evidence? Generally, it goes to both. It depends. So, in order for a piece of evidence to be admitted, there must be foundation established. The foundation is simply the evidence that supports the idea that the evidence is what you're saying it is. Let me clarify that. So, if I wanted to admit a contract, say, I could call somebody who was a party to the contract, someone that signed it, right? And I would need to say, you had conversation with this other person, right? And over the course of a few days, you guys sent some emails, and then you agreed to do business together, and then he sent you a contract, right? Yes, I'm handing you what's been marked as whatever Exhibit A, and this is in fact the contract that you signed. Yes, okay. That's the foundational stuff. It's enough evidence to prove that the thing you're trying to admit is what you say it is, right? And so with chain of custody, you're doing essentially that. You're preserving that foundation so that when it comes time to admit it into testimony or into the trial, you have the proper foundation. Now, if we're talking about, say, DNA, say there's a vial of someone's blood. And that's usually like the chain of custody. All right. Well, I drew his blood. The nurse drew his blood and put it in a sealed bag and initialed it. And then when it got to the lab, and then
Directions to Great Wolf Lodge.
No, Siri.
Wolf's
Glen Restaurant.
One option I see. Woods Garden Supply on Benedict Canyon.
Siri. Wolf's Glen Restaurant.
Valhalla's in the
in
background.
One option I see. The Wolseley Restaurant.
What's up, buddy?
That was awesome. You interrupted my thought.
I know. I was gonna try to wait until you were like finished with your point, but you talked forever, so it didn't really work.
I just talk. How you doing? You were hanging out
Good.
with Megan, I heard, huh?
Yeah, I was hanging out building Legos with Megan today.
Nice. Oh, pre-Lego stream build? Is that what you guys were going on?
Well, we're those What the Hails, the YouTubers that are all over the place right now.
Yeah.
We were watching a bunch of that stuff, so we're building some of the ridiculousness that are involved in that case and situation.
I see.
I built an RV today, but I don't have very many Legos, so it doesn't really look like an RV.
Nice. Well, let me finish my point that I was making real quick.
Sounds good.
So the officer who takes the sealed bag with the vial of blood, initials, and says that I transported it. And then when the lab gets it, they open it up, they sign and say that they opened it up. The whole idea is, at the end of the day, to have enough foundation to say, yes, it transferred from this person, this person, this person, that it is in fact this person's blood that we're now admitting into testimony. Now, if there's a breach in that somewhere, then you lack the foundation and you can't admit it because you haven't established proper foundation. So it goes to the admissibility, yes, but you can also use it to challenge the credibility of it. Like, well, this officer who transported it didn't sign it. You're like, okay, but we have the nurse that signed off that said that she drew the blood from this person. And then we have the lab that says that they opened it, this exact same vial. And so while we're missing that in-between transporter, it's still close enough. So we'll admit it, but we'll allow you to challenge the credibility. So it depends on the level of violation as to whether or not it's going to be inadmissible or just goes to the weight. All right. I'm skipping all the way to the front of the chat because I don't know where I was.
Sorry.
Mahalo screwed me up. No.
Sorry. It happens.
Did you see at the beginning of my stream, though, I played this guy side by side with his testimony from Jennifer's trial. And he's like, it's the exact same. Everything is exactly the same. He's like, he's crying at the same time, talking about the same things. He's wearing the same suit. This is literally Two
It's
different
like a
trials.
rehearsed play, man. It's like
I know, right?
stage acting. Oh, that's not genuine. That's not genuine at all.
I know, right? This is two different trials separated a month apart from each other. And he's like crying both times, holding back tears, talking
you see
about
that,
teenage girls.
Did you see the Baker raid that came in? He's all upset with you because you didn't acknowledge him.
Oh my God, no! I'm sorry, I've been way behind in chat.
He's
Hey,
confirmed.
Baker Raiders.
Also, did you notice that Megan's here?
No, Megan.
Say her name and she appears.
Oh, hey, Megan. Oh, you got to go. I'm looking forward to our Lego build 2 Saturdays from now. Not next
Not
Saturday.
this Saturday, but
after.
next.
Yep, I'm gonna do a little
23rd,
Lego
I think
build.
it is. Yeah. She's gonna. I
So-
think she's free forming. I don't think she's getting a set. She's got more Legos than you and me combined by a lot.
I heard, and I've been watching, or not watching. I've been seeing her. Her
And now she's
exes.
got me saying Legos instead of Lego. I hung
It's
out with her for
Legos.
2 days, and she messes up the entire
There's
thing.
no S.
She says it that way. Now I'm saying it that way.
It's a Lego, but ask the Dane. Is it Lego or Legos? It's Lego.
Oh, it's Lego. I know the right answer.
What was I gonna say? I was gonna do a free form, but I've done 2 of them in a row, so now I'm actually gonna get a set for this one.
Okay, cool.
But I want to do the sailing boat. So
I
that's
saw
gonna be
the
mine.
catamaran yesterday.
Solomon built it, the catamaran, but I want to do the monohull because monohulls are better.
I haven't
If
seen
Solomon's
that one
listening.
yet still.
I just happened to stumble across. I didn't know there was any sailboats, and then after he built his, I was like, "Ooh, I'm gonna go look."
I think I've seen the catamaran or whatever. I think I've seen that a couple times, but I've never seen the monohull.
Oh, okay. Did you watch any of this trial today, Mr. Valhalla?
No, I
No.
was busy.
I mean, it was literally this. I mean, this is what it was. It's in, the first witness was identical, testified to the same thing.
Oh, so
No cross-examination because there's no needed. This guy's going to be crossed tomorrow. So I'm really curious to see the difference between the 2 cross-examinations between Jennifer's attorney and James's.
have they crossed the witness yet?
No, it starts tomorrow. Tomorrow
So
morning.
tomorrow will be the first chance we get to see their plan of attack, so to speak.
Mhm.
Cool.
And for those who missed my conversation at the beginning of the stream about what happened at the end of trial, let me go over that again. All right, take care, Megan. I will see you in like 9 days.
Yeah, we're building Turtle Purgatory. That's what it is from the Hales case.
Turtle
It's-
Purgatory, huh?
Yeah, the lady's got it like a turtle and tortoise rescue. But
Oh, that's right. I heard about
yeah,
that.
yeah. And the Hales actually came on today for a while. It was pretty cool.
Oh, and on stream or on
Mhm.
chat or what?
On stream,
okay.
they came on panel.
Oh, nice.
Yeah, it was cool. It was
Yeah,
cool to get to
that's
talk to them.
that's an interesting case. I was getting a little flack from their followers.
For not.
Whose stream was I on? I jumped onto somebody's. And MG's. I was on MG's.
Oh, there you
stream.
go.
Yeah, and apparently, because I was like, well, what he's doing right now, what the judge is doing right now, I'm fine with. But apparently, I didn't watch enough in advance.
He's
I was
his whatever he did like just now recently, like the most recent stuff he's done. He's kind of, I think, learning that he's messed up for a little while, right?
I know he was pissed that it was out there on YouTube.
Yeah, I think he's backpedaling a little bit now. But the first couple of hearings that we watched, they're pretty biased. Pretty biased.
I was just looking for the picture of the creepy FBI guy, Fox, and I didn't see it. He's probably going to testify tomorrow, though. Did you see him though in the background? Let me see if I can pull it up. Let me pull up my earlier.
He is
stream.
creepy looking.
He is, but there was a point.
He looks like a Fed, is what he looks like.
Well, fair enough. There was a point though during the testimony. Oh, that's my current stream. No, I want to find the earlier stream. There was a point during the testimony. The one thing I do like about this view is that you can get like the faces of people as opposed to everyone's back. Let's see here. So Oh, yeah. See, you can see him there behind the prosecutor's head. He's sitting back there. But at some point, I think it was maybe during the first witness, he was just looking so creepy. Doesn't he look creepy?
He
sitting
looks
back
so
there?
creepy, man.
Oh, this is opening statements. This isn't the first witness. Yeah, there he is. That's the exact shot I wanted. He's just sitting back there. He looks so freaking creepy. Doesn't
He
he?
looks like who you would cast to be the creepy federal agent that goes like rogue. You know what I mean?
I said he'd be the one that you cast if you were for a school shooter.
I was gonna say that, but I thought it might have gone too far.
No,
I
I
thought
said
that
it
might be a
live
little too
during
far.
Jennifer's trial. I was like, he looks like the shooter. Like if I was in the school, like as a principal or a teacher or something, and that was going on, and that guy showed up, I'd be like, he's the shooter. Arrest
You're
him.
not wrong, brother. You're not wrong.
I don't have the still. I think it's on my Discord. So if you guys remember, you can check that out.
Should make him an emoji.
Mm-hmm. Don't worry about Flack. You were right about what you said. I know I was right. I'm always right. I'm just pointing it out. But yeah, so again, all right. So this was the first witness, who was the first witness in Jennifer's trial as well. She was the teacher that was shot in the arm.
I did actually catch a little of that at some point today.
Okay.
A little bit.
So the motion hearing at the end of the day, though, let me recap that again. So this was a
I'm gonna go
motion
grab my
filed
drink.
under seal. Sure. This was a motion filed under seal. That's why 8.119 came into play. And they played coy with it because they didn't want it out in the public. So the little bit that we know is that James apparently called somebody from jail. We don't know who the person is, and we don't know what was said. But it seemed like it was potentially a violation of the gag order. There's been a gag order in place since the beginning on this case that no one could talk about anything. Because of this, the defense or the prosecutor wanted all communications from James to be restricted. Like basically he wouldn't have access to a tablet or a computer or anything. He could only call his attorney or call clergy. The defense objected. First of all, the defense objected to even raising the issue publicly because she said that they were handling it already, meaning that they were talking about a possible resolution. So the defense objected to that. But then after they had some coy conversations on the record, went off into the hallway and came back with a resolution. And the resolution is that James can communicate with his attorney, assuming clergy as well, and can conduct research for the purposes of assisting in his defense. So he will presumably still have access to a computer or tablet, whatever, but is not permitted to communicate with anyone else at all, period, until the jury has returned a verdict. So I don't know who he talked to. However, if I'm connecting dots blindly, there was an evidentiary issue brought this morning regarding text messages between Jennifer and one of her friends. They don't mention the friend's name. The judge excluded those text messages from being admitted unless they're going to be used for impeachment purposes. And then the judge would be willing to reconsider her decision. I don't know why you would have text messages being admitted. And they were very coy about it as well. Like normally the judge is like, we have Facebook messages between these two people. I don't find it to be, an exception to the hearsay rule. So I'm going to exclude it. We have these other text messages where Ethan was telling his friend that he's going to do something really bad that was sent on November 21st, 2021 at 2:30 a.m. Again, I don't think that meets any of the exception or the hearsay exception. So that's going to be excluded. And then there's this other text conversation. That's just going to be, like they didn't go into detail about it.
What do you
So I
think
have a
it's
feeling.
about?
I don't know. I don't know if he was like communicating with maybe a witness that also testified in Jennifer's case. I have no idea. I'm all speculating, but I feel like those two things are tied together some way, shape.
I feel like if it was that serious, blatant, right, they'd probably be making a way bigger deal out of it. If he was talking to witnesses,
the prosecutor did say like this is a huge issue, Judge. But I think we have a resolution. Like he talked about this being a major issue. I don't know if it's what exactly it entails, but technically speaking, you can't connect the dots if you're blind. Well,
you can't if the dots are braille.
Yeah. There you go.
Yeah.
I was gonna go with the whole blind squirrel finds a nut every once in a while, right? But but I have no idea. But so the nature of the argument at the end of the day was, what are we going to do about this weird motion because they're alleging that James violated the gag order, and they came to a stipulated resolution, and everyone was sort of tongue in cheek about it, and the real issue wasn't revealed to us mere mortals here in the public. So, and I did look for the motion itself in the docket, and it's not publicly available, which means that it was
sealed.
it was filed under seal under 8.119. So how's the RV? Fox wants to know.
It's not great. I need more blocks, so I don't have enough of the colors I need, right? And it definitely don't have enough to like go all the way up and over, but I decided to do like a diorama style here. Okay.
All right, and we're gonna do full screen for you.
Decided to do diorama style. So we got the the wheels, double axle.
I like that.
Trailer hitch in the front. You can't really tell, but there's a little wheel down there.
I feel like you're missing a few, like the walls in the roof.
Yeah, well, the walls are the part that I'm missing for sure. But I got the door, and it's just the front walls and the top half of the whole thing. Just a little kitchen sink in there. Got the table, the TV. Got a bed up here. Yeah, little bed, pillow. Got the ladder on the back. Got all the lights back there. All I need, and then the electrical cords, obviously, that are everywhere.
I definitely need the electrical cords.
Is
it falling apart in your hand, by the way?
One of the electrical cords came loose. What
about the news story? So I think the judge was being a little tongue in cheek. I think what she was hinting at is if we have this motion and state you filed this motion, so if we're going to hear it, it has to be public. That's what, and the judge said under 8.119, I don't have a way of sealing this, so it's got to be public, state. And the second it happens, it's going to be all over the news. And that's what the judge said. She wasn't saying that there was going to be a news article, like definitively, like she knew about one. I think she was saying, like, listen, if we're talking about this, it will make the paper. And so again, that's what.
So apparently it is a big deal.
It's a big deal, but no one's talking about it. Oh, also, I don't know if I mentioned during this stream at all. I don't think I did. There was a juror that didn't show up on Wednesday after they were there on Tuesday, so a bench warrant was issued. And I'm also going to follow up on Jennifer's trial. There was a guy who was charged with contempt of court for taking pictures of jury members during her trial. And so I want to figure out the results of that. So I got to go through and grab the order on that and figure out what happened there.
He stayed in jail for a little while.
I don't know. We're going to find out. But so there's a few things that I'm going to try to do behind the scenes and some orders I'm going to try to get a hold of and things like that. She said in 8 minutes. Yeah, but there is no news article. Let me see. I mean,
what time was it though? Was it just like the 6 o'clock news was in 6 minutes or 8 minutes or whatever the hell it was?
She said it at like 4:30. I don't know.
5 o'clock news.
So the 5 o'clock news. Let's see. Let me see here. James Crumbly. L-E-Y. Let me search the news articles for James Crumbly. James Crumbly trial begins. Watch a recap. They won a trial. Judge excludes texts between shooter and mother. Opening statements. There's nothing in here regarding any sort of shenanigans. Let's see here. Trial underway. 2 witnesses testify in first day. Let me find the most recent updated one, which was 1 hour ago. Let me see if there's anything in here.
The 6 o'clock news.
The 6 o'clock news, yes. Let's see here. You know, they post the original story and then they update it towards the end.
I hate that. Got to read them backwards.
Yeah. Let's see. First witness to take the stand. Nope. Not that one. Let's see. 3 hours ago, that would be like 4 o'clock. 911 call played. They did play the 911 call. They did do that. Where he's missing his gun. Let's see. Oh, and they tried to say like he was at the meeting area where everyone was supposed to meet up, but instead he went home, and he had the opportunity to go home after the meeting before the shooting, and he chose not to. And the defense was like, he works for DoorDash, but just because it's DoorDash doesn't mean that he shouldn't take his job seriously and actually like go to work.
Right.
You know? So that was pretty good. Little back and forth at the with the openings. Let's see. Wounded teacher testifies. I could show you what I'm looking at. This is the Detroit Free Press. Let's see. Knew his son was in distress. He knew his son was in distress. Let's see. Defense says, if the jurors follow the law, father will be acquitted. I agree with that. And that's it. So, yeah, I mean, I don't really see. Oh, sorry. I thought I was showing you guys.
I was wondering. I was gonna ask, but I was like, he clearly
Just
sees
speak
it.
up,
Like
man.
it's
Speak up.
not even on the. It's there's no way he's not noticing this.
Yeah, this is, thanks. You're like the greatest co-host ever. I slid it over to
Which
the other
did
screen.
nothing. It did absolutely nothing to anything.
Damn it, Valhalla.
Oh, that's funny. Oh,
Are you going to MG tonight?
I don't know.
You gonna do? What do you guys talk? Are you guys doing more? What is it called? Hails?
Yeah, he has been. What the hails?
With the hails, yeah.
What the hails? Yeah, he's been covering that. Jumped on the first night or two or something.
Okay. So this is a bit of controversy, and I believe if the James gets convicted, both James and Jennifer's case could potentially be overturned on this issue as well as the journal issue. The court has ruled that there's a bunch of hearsay exceptions, right? So obviously this is an out-of-court statement offered for the truth of the matter asserted. And there's, the person making the statement is not on the stand, not Jane or Ethan is not. And so it should be excluded as hearsay. But the judge made a decision that this falls under the present sense impression exception, which means that if somebody sends or makes a statement in the presence or in the present moment as they're experiencing something, then that's an exception to the hearsay rule, ideally because the statement would be more likely to be truthful. So, oh my God, I'm on fire, that kind of thing. And, it's more likely that they're actually on fire than that they're not. So that's why that exception exists. And so the judge used that exception to allow for these text messages to come in. But I don't think it qualifies under that because he's texting his friend, random things. And not necessarily his present sense. It's also the same basis for admitting the journals, even though Ethan isn't testifying and there's no foundational evidence to establish that Ethan wrote the journals, let alone when he wrote them and what he was actually thinking at the time that he wrote them. So that's a very possible. If he's found guilty, just like Jennifer, that would be one of the reasons why this could potentially get kicked back down.
They're going to find him guilty, Dave.
I'm holding out hope.
They found her guilty. she had way less to do with it than he would have, in my opinion, and he didn't have shit to do with it either.
The state did not bifurcate. It was actually a motion by Jennifer's counsel to bifurcate. And then James filed a motion as well asking to bifurcate. And this was after 2 witnesses from Florida were placed on the witness list. Now, we didn't see any witnesses from Florida testify in Jennifer's trial. Presumably, they are going to in James' trial. The only people that I know that live in Florida that could be potentially relevant would be James's ex, although I do believe Jennifer's family is also in Florida. But I believe James's ex-wife and child is in Florida, so maybe that was the issue. I don't know. There were supposed to be 2 witnesses from Florida that were placed on the witness list, and that caused a conflict, and that's why they bifurcated the case. But again, there were no witnesses from Florida in Jennifer's trial, so I have no idea. Don't make us cry, Valhalla.
Yeah, my bad.
Why is everyone going to cry?
Because they have hope for this guy getting the right verdict, and ain't gonna happen.
Yeah. So, I mean, other than what I've just talked about, the case was pretty much just a redo of Jennifer's case. There's nothing really spectacularly new that happened. Some of the evidence that was previously admitted under Jennifer has been excluded, which would be appropriate because they were communications from Jennifer to other people. Ethan's communications to other people are still admitted. And we did get a bit more information about Ethan's friend via the text messages between James and Ethan's friend's dad. Other than that, it's pretty much the same thing. So I don't really have much else to say about this case. I will post a stream for tomorrow morning at 9 a.m. We're going to do the same sort of thing. I'm just going to stream it live with the Zoom feed. You guys feel free to comment. I don't know if anyone's going to stream snipe me. I don't think Farrell's going to tomorrow. I think she said that she's not going to be able to. So if anyone else wants to, go for it. And then I'll do the same sort of thing. I'll come back here tomorrow night around 6, see if there's anything else to talk about, and we'll go from there. And this is about it. Bahal, you got anything coming up?
I don't think I've got anything planned till our Lego stream with Meg.
Okay.
Oh, speaking of, I did put her link in chat. She dropped in earlier, and I should have done it then. But you know, I'm a bad mod, so I put it in there now. If you don't know who she is somehow,
Megan Fox.
Not sure how that would be, but
if you're watching me and you don't know Megan Fox, no.
Yeah, I don't know what I don't know how you guys are doing. I don't know what you guys are
check
doing.
out Megan Fox, not the actress, but the more qualified,
The
educated,
medium smart ones.
the medium smart one. Yeah,
The normal thumbs one.
yeah, the one that doesn't have toe thumbs.
Exactly. Straight did.
What does
post?
she
Okay,
write
thank you.
for? Do you know? What does she?
PJ Media, I believe.
CJ
Still,
Media?
I hope.
Okay. I know she did an article about Jennifer Crumley. You guys should really check it out. She sent me a link. Actually, you know what? I'm going to put the link. I'm going to find the link first, and then I'm going to go ahead and put the link in chat. She did an article covering Jennifer Crumley after the conviction. So let me find her real quick, and then because I know she sent me a link a while ago, and then I'll put that in there. Oh, I got a bunch of Lego stuff. Hang on. Gotta get past all the Lego messages, and then I can find her actual article.
I had
There
like
it is.
3 people today in different chats. I shouldn't say random, different chats, offering to send me Lego. I was like, oh, I need a PO box like yesterday.
Nice. All right, guys, go click on that link and check out her article. It's really well written. I may or may not have given a quote for it.
That a boy. That a boy.
Yeah. So yeah, go check it out, guys. Yeah, and subscribe to Valhalla as well. I'm gonna have to put your link in the description so that people coming back later can find you, and then I'll put Megan's in there as well.
Did I tell you how
And-
many subs I've gotten in the last few days?
Thousands. No, we got
no, definitely not thousands. But I've gotten like, let me double check. So I'm not lying to you. My numbers are good. The what the hills
make
people.
sure you don't lie to me.
like 350 new subscribers.
Nice.
Yeah, I'm up past 1.8.
If you guys want to see some goat videos too, he has those.
I sure do.
There's your channel.
I was
Nice.
pretty proud of myself. I thought it was pretty
1.82.
cool. Yeah. You're not sharing. There you go. Heck yeah.
You have controls to share. You just choose not to.
I was going to. I was just trying to be a good co-host and let you do it.
So there you go. Nice. Good numbers.
Heck yeah.
Look at all the Lego streams pop up.
Right? It's good. It's good, y'all.
There you go.
Y'all are treating me good. I love you. It's amazing.
Go check out Goats and Legos and Random War Stories with Valhalla Awaits.
That's pretty much it, too.
Uh,
Oh, it's good.
I don't think I'm going to do interviews anymore. I heard you had an interview. I've been working and streaming, so I haven't watched it yet, but I'll go check it out. All right. That's about all I have for today. So I need to set up a redirect. That's what I need to do. Who's streaming right now?
Are you
Oh,
looking or you
Mo.
want me to look?
I got it. Mo. Mo is streaming. I'm going to send you guys over to Mo. If you guys don't know Mo in the Deep, she is she's awesome. She got
She
her
is.
start right here on this channel.
Mo's awesome.
And she does the news. It's better than like mainstream media. So go check it out. She does little news stories. And she does them twice a day, actually, twice or even more, maybe. So go check her out. And we will see you guys tomorrow at 9 a.m.
Later, y'all.
See you guys.
When I was young, my daddy said, gotta keep one eye open in your bed. Cause there's a time coming when the devil gonna come for you. So my trigger finger, stay prepared. I've got my weapon and I got my prayers. Cause